Yes.
Good morning, Your Honors. My name is Michael Rabia, and I have the privilege of representing the appellant, Jill Kavaleski. Ms. Kavaleski is a Boston native and a graduate of Suffolk University with master's degrees in criminal justice and public administration. She worked 7 years for the Veteran Affairs Office of the City of Boston. She's currently married with a young daughter, and she is commissioned as an ensign in the U.S. Naval Reserves. This appeal concerns her application to join the Boston Police Department. After an extensive background check, the department extended her an offer of employment conditioned solely on her passing medical and psychological exams. The New York Police Department had previously offered her a position as a police officer after she had passed all its exams, including psychological testing. She has an unblemished employment record, both then and now. She has no history or diagnosis of any psychiatric condition or disorder or substance abuse problem. And despite these facts, the Boston Police Department withdrew its offer of employment after its psychiatric screeners concluded that she was not psychologically fit to be a police officer. In reaching that opinion, the screeners applied the governing regulations incorrectly, and they relied on dubious speculations. And let me give you two examples of this. If you look at the screening reports from the psychiatric screeners, there's an inordinate focus on her physical appearance. They focus on what they claim is her messy hair and her thinness. For the record, then and now, she's about 5 feet 6 inches tall, and she weighs approximately 120 to 125 pounds. What is the psychological significance of her appearance, though? For that, the screeners give us only speculations. For example, and here I'm going to quote from page 534 of the appendix, which is the transcript of the hearing that was held before the Civil Service Commission. Dr. Julia Reed, who is the final psychiatric screener and the one on whose opinion the decision to withdraw the offer is based, testified that when there are, quote, issues related to someone's grooming, I wonder if it's a marker for some kind of psychological problems. But did she find this to be the case for Ms. Kavaleski? No. I'm going on to quote. I wasn't sure if that meant something about her ability to observe herself. I didn't know what it was a marker for, but it was just striking. And we have similar speculations in the very first report that was prepared by Dr. Brown. That's at around Appendix 155. Another example of a dubious speculation.
What do you, and I don't know whether well, I should ask you this. Is it proper in this third bypass decision to be considering, if I understand correctly, that in the first and second, that Ms. Kavaleski scored on the MMPI in a way that invalidated the test? Is that part of what we should be looking, or was fair for Boston to look at the third time around?
The third time around, I don't think it is fair. I mean,
I know she took it a third time, but are you saying that's what they need to look at, that third test?
Yes, I think the department's been pretty clear before. I think it was clear before the Civil Service Commission that it's resting on the third so-called bypass decision, and I think there's a terminological issue there that I'd like to get to in a minute. But that's what they focused on, that third bypass decision. Now, the fact that she'd been through the process before, I think that's relevant to what happened later, because we believe that what happened at the beginning infected the process all the way through. But you have to keep in mind what it means to invalidate these tests. The tests that you mentioned are written psychological exams. They have multiple questions. I think in total it approaches 1,000. They are embedded in the test are certain questions that the test makers have deemed to be of special significance, and so if you answer them in a certain way, it raises a red flag. And it can raise a red flag with regard to what they call the clinical scales, whether she has some kind of condition or disorder, and with regard to what they call validity scales, whether or not she's answering honestly. So to say she invalidated the test, she answered in such a way that made it unclear whether she was being as forthcoming as the test takers or the screeners would have liked. And this is brought up in the exams. But I think the real focus is on the third round. And getting back to another instance of a dubious speculation, at one point in her testimony before the Civil Service Commission, Dr. Reed expressed concern that Ms. Kavaleski, a Boston native, had chosen to go to Suffolk University rather than going away to school. And she suggested in her testimony that this might be how she manages anxiety, by staying in a familiar setting. But did Dr. Reed find that she had an anxiety disorder? No, she just says it's a possibility. So if you look at the record of what the screeners found, it's very speculative, and we don't think it supports the finding of a psychological disqualification. And getting back to this issue of a bypass, now what happened was she was notified of the so-called bypass in September of 2007. She appealed to the Civil Service Commission under Chapter 31. She appeared pro se. She did not have an attorney. She did not have a psychiatric expert. Nonetheless, she prevailed before the Commission after a hearing in April 2008, and the Commission ruled that the police department had failed to carry its burden of proof as to whether she suffers from a disqualifying psychiatric condition. And let me be clear here. This is simply a ruling about the department's carrying or not carrying its burden of proof. The Commission did not take it upon itself to assess her psychological fitness. And this distinguishes it from other cases, such as there was a Monroe decision that Justice Gantz authored about 10 years ago, where he faulted the Civil Service Commission for making an affirmative determination.
Well, you can assert that, but one might read into that decision some degree of making its own assessment of her psychological fitness, don't you think?
You mean in the Civil Service Commission that's the subject of this appeal? I don't think so. I think the issue is what the department has to substantiate in order to prove that she's in order to carry its burden of proof as to whether she suffers from a disqualifying condition.
They have to show that the justification was a valid one for the bypass.
That's right. Based on facts, and so this gets to the whole issue of what they have to show. The regulations promulgated by the Human Resources Division distinguish between Category A conditions and Category B conditions. And Category A conditions are automatically disqualifying, and for shorthand we can say these are DSM-4.
That's not the issue here.
That's right. The issue here is, I think it's fair to say, whether she suffers from a Category B condition. Now, nowhere in the reports is there any discussion of Category A versus Category B. And the question in this bypass, I mean, this is not, I mentioned earlier that this is a special kind of bypass. There's the majority, in my understanding, the majority of bypass decisions are you look at a discrete event in the past, and you see, for example, in the Beverly case, the issue there was whether or not the candidate had committed the misconduct of which she'd been accused. It's discrete, it's in the past. So the Commission has a hearing to decide, that issue. Here, she is being disqualified because of a psychological trait. It's enduring. It's not something that you can hive off in the past. So the way she presents to the Commission is certainly something it can take notice of. And so what the Commission found was that the factual underpinnings of the conclusion that she was psychologically unfit didn't pass muster. And let me back up a second about Category B. Category B requires that the condition be sufficiently severe as to pose a significant risk to health and safety, and it also requires some examination of the patient's of the candidate's history. In this case, Dr. Reed had some reservations, had some concerns about Ms. Kavaleski, but she didn't bother to conduct history. She found no real-world manifestations of the alleged problems from which she suffered. She didn't contact any references. She didn't do any background investigation. She relied on how on the written test results and how Ms. Kavaleski presented to her in clinical interviews. We submit that in and of itself is an improper application of the Category B standards.
I guess two questions. First, what's the result of Judge Gaziano's decision? Does it mean it goes back to the Commission for a new hearing?
Well, it depends on what you do. I mean, if you simply reverse Justice Gaziano's...
Let's assume we affirm it. What's the consequence? Does it mean that it goes back to the Commission for a new hearing where the Commission does not consider the prior expert's testimony? Or does it mean that she loses?
Well, I would submit that that I would think it would not have to go back to the Commission for a new hearing, because I think that he ruled on very narrow grounds.
But he never ruled, as far as I can tell, as to whether the evidence was sufficient.
He did not. That's right. He found an error of law. That's the only thing he found on narrow grounds, which was the alleged reliance on this other case, the Roberts case, as to whether or not psychologists are the only qualified professionals to interpret written test results. First of all, that misstates what the Commission found. There was no finding that they're only qualified professionals.
But the question is, if we affirm, what happens? What's the next step in this case?
Well, I would submit my argument, and I'll just to shorthand it. The argument is I don't think that that's an error of law because the alleged reliance on Roberts is inconsequential. It doesn't make any difference. At worst, I would think you remand to the Commission to see if it can reach the same result without relying on Roberts, if you think that there was some kind of reliance. I don't think there's a need for a new hearing. But we're arguing that, of course, that the Superior Court's decision should be reversed because the finding of error was incorrect, and you should determine that as a matter of law, and that the Civil Service Commission's decision should be reinstated so that she has the opportunity. And reinstating the Civil Service Commission does not make her a police officer, not automatically.
Right.
It wipes the slate clean, so to speak.
Let me ask you another question. Let's assume you had the psychiatrist, and there had to be two because it's phase 1 and phase 3, and both of them say, this doesn't fit into any neat psychological category, but the fact of the matter is she's simply too rigid to be able to perform the kind of discretionary task that a police officer needs to perform on the street, and because she can't bend, she'll break. And I'm not going to give it a psychological name, but that's basically what we find. Can the board speak to her at the hearing and say, I don't think that that's right, and say it's not adequate to support the BPD's finding?
I think the board can say that. A lot depends on what comes out of the hearing, but I think we have to. I actually think the way you put it is an inaccurate representation of what the appropriate standard is, and I would like to distinguish between what I call a gatekeeper function and a scouting function. The way the regulations are written, the testing phase only comes in once there's been a conditional offer of employment. The police has conducted an extensive background check. They investigated the candidate. They've decided to extend an offer. It's only at that stage that you get to look at, that you get to subject the candidate to psychological screening. And there, under the governing regulations, the examiner is supposed to ascertain the presence of a disqualifying condition, whether it's Category A or Category B. So it's a gatekeeper function. You're trying to see whether there's some condition from which the candidate suffers that would disqualify them from performing the essential functions of the job. That's in contrast to what I would call a talent scout, where you're looking out and saying, how is this person going to do as a police officer? With respect to psychiatrists, that's not their role under the regulations. If they don't find a disqualifying condition, all that happens is the candidate enters the police academy. She's subjected to training. The police department gets a chance to vet her in something close to a police functioning world, and she can wash out of the academy. And then after that, you still have to go through probationary year, where she can be terminated without the departments having to meet a just cause standard. So there are a lot of steps, from A to B, and I really want to stress that I think it's important that the psychiatrists limit the role to exercising a gatekeeping rather than a scouting function. And here, there's testimony that the Commission relies on from Dr. Reed, granted in other cases, Booten, and there's the Booten decision and Coots decision. These are at tabs 4 and tab 6 of our appendix of authorities, page 15 of the Booten decision and page 10 of the Coots decision, where she describes her vision of her role in what I would characterize as a scout rather than a gatekeeping function. So given that background, then what happens is then the police department has the burden of showing that there's sufficient factual support for the conclusion that the psychiatrists reach. And I think there are, what conclusion the psychiatrists reach, I think there's a host of questions in there that could be unpacked. One is, okay, what is the psychiatric condition? Here we find there's a finding that she's interpersonally stiff. What does that mean? She's reserved. I mean, I think it's still within the domain of the Civil Service Commission to say whether or not this really meets the standards of disqualification. But I think that's a very limited role there, and we don't want to rest on that. The real issue is what are the factual predicates for the conclusion? And there, the Civil Service Commission is the finder of fact. Its findings are entitled to deference. And here, the Civil Service Commission properly found that the factual underpinnings for the bypass simply weren't present. And I see that my time is running out, but I want to stress that all that happens if you allow our appeal is that she gets a chance to be a police officer. She doesn't become one, she gets the chance. And we think under the governing regulations, she's entitled to that chance. Thank you.
Good morning, Your Honors. May it please the Court, my name is Nicole Taub. I'm here on behalf of the Boston Police Department. And I'd like to bring the Court back to the actual question before the Civil Service Commission when it heard this case in 2008. And that was it reasonable for the Boston Police Commissioner to rely on the psychological assessment of the second-level screener to bypass the appellant, Ms. Kavaleski? And I would support that, or submit to the Court, that it was more than physical appearance. It was Ms. Kavaleski's extreme defensiveness, her lack of interpersonal liability, her concrete responses to questions, and a general rigidity, as the Court mentioned, when discussing simple issues such as her family life, her prior employment history, moving violations. And there are specific examples in the record of those traits that were identified by Dr. Julia Reed in this evaluation. For example, with regards to the lack of interpersonal liability, Ms. Kavaleski was asked about 2 separate moving violations she had received prior to the evaluation. Instead of acknowledging some type of misaction on her part that resulted in those moving violations, it was, "I wasn't speeding that much," or "the case was dismissed." Nothing in Ms. Kavaleski's answers to those questions displayed an inability to look within herself and accept some responsibility for her actions. It was always about the circumstances or the settings that presented themselves.
What was the disqualifying psychological condition that the psychiatrist determined?
Well, I'm glad you asked, Your Honor. And I would submit that the psychologist is not required nor expected to identify a condition or disorder.
Isn't there supposed to be something that falls within Category B?
And in this case, there were several psychological traits that were identified by Dr. Reed through the course of her evaluation.
Traits are all that are required?
I would submit, yes, psychological traits.
And on what do you base that?
I think that it's a pattern of behavior or traits that have presented themselves in the individual is part of the definition of a Category B that will interfere or may interfere with their ability to perform the essential functions of the job. So what was done with regards to Ms. Kavaleski was those traits were identified by Dr. Reed and corroborated by Ms. Kavaleski's incredibly defensive, not to the point of invalidation on the 3rd round of testing, but corroborated the concerns raised by both the MMPI-2 and the PAI in this case.
I guess I have 2 questions. When you say may interfere, do you agree, or is it the case that in order to bypass, the Boston Police Department has got to satisfy Category B in this case?
I think it has to identify either a Category A or Category B
And wouldn't it
condition.
be, and isn't it the role of the Civil Service Commission on this appeal to decide whether the police department was justified in its conclusion that Category B was found here?
I would agree that that's the narrow role of the Commission, and in doing so must determine whether or not it was reasonable for the department to rely on the recommendations of its psychological screener in making that assessment. It's our position that in coming to its conclusion in this case, the Civil Service Commission's decision is not based on substantial evidence, and that's shown through the hearing officer's own layperson observations of the appellant that extend well beyond a credibility determination, where he goes on to describe a scenario where he calls the case and the appellant answers, and she's so well represented, which he later goes on to say, in such stark contrast to the observations of Dr. Reed that led him to think she was counsel. That was a strong basis for its decision in disregarding or refuting the findings of Dr. Reed.
Is it, in response to Justice Gantz's question before, if we were to, I'm just trying to figure out what Judge Gaziano did. Sure. What is the result of his decision?
I think that what Judge Graziano did was vacated the commission's decision because he found that the error of law
I
committed.
understand why he did, but does that mean it's another hearing before the commission, or does that mean she's out of luck?
I think that unless Ms. Kavaleski takes another civil service examination and scores high enough on the list, she's not eligible for further consideration by the Boston
So it
Police
wouldn't go
Department.
back to the commission in your view?
I do not believe there would be anything to support a remand for a new hearing.
And finally, I will stop, but there's a reference in Dr. Reed's second-level psychiatric opinion that's, oh, okay, maybe that's not. Which is the, if you have the record there, which is the one that's relates to this time?
It would be the June 30th report that begins on page 245 of the record.
Okay, thank you.
You're welcome.
What is the role of the Civil Service Commission with regard to these psychological evaluations? I mean, they don't get to the commission unless there are two psychiatrists who found somebody to be unfit. What if the commission says this is all just psychiatric gobbledygook? It's based on nothing. It's based on silliness, such as her physical appearance, whether her hair was well combed. Are they ever able to say this is gobbledygook based on nothing and we're not going to uphold it?
I think it depends on the facts before it, particular to each individual record. And I think an appellant has the opportunity to put forth a defense which may or may not include an expert, but this is an expert evaluation. This is a medical assessment of a candidate that the commission then has to determine, was it reasonable for the department to rely on that evaluation? This is a well-experienced and well-versed psychiatrist who's been doing these evaluations for the department since the mid-90s. There's no question as to her skill and expertise, and in this case, there was no question from the record that she identified these very concerning traits, as well as two prior doctors who had evaluated Ms. Kavaleski in her other evaluations that deemed her unsuitable because of the high-stress nature and the specific requirements of the job of a police officer.
But can't the commission evaluate the reasons and say, for instance, that it's pure silliness to say that because she was from Boston and went to Suffolk College and Suffolk for her graduate degree, that shows a lack of adventurousness which would be necessary in a police officer? I mean, at some point, can't they say that's just plain silly?
I think that the commission can disagree with the science behind a psychological assessment, but I don't believe that's their role in evaluating the department's reasonableness.
So they have to accept that, too, according to you.
That it was reasonable?
Yes.
Well, I think that's the question before them. Was it reasonable to rely on it? And in this case, the commissioner was faced with very concerning traits identified by the medical professional employed by the department. And as a result of those traits and the report that was submitted by Dr. Reed in this case, yes, it absolutely was reasonable.
Okay, but the question is not whether the traits are concerning. I think everyone agrees that too much rigidity is a problem for a police officer. The question is whether or not they had adequate basis to reach that conclusion.
And I would submit again that it was Dr. Reed's testimony and the specific examples cited both from the testing and from her interview that make it reasonable in this case because there's nothing in the record to refute that. There's the appellant's opinion that she is suitable. And what does she base that on? Not a psychological or medical evaluation. She bases that on her employment history and her unblemished supervisory recommendations.
And what's wrong with that?
There's no dispute. There was no concern on the department's behalf from Ms. Kavaleski's background. She passed the background.
Psychiatrist or the psychologist ever speak to any of these people and determine whether or not their observations of her were, which seem pertinent, would reach different assessments of these traits that the psychiatrist identified?
She did not, and I don't believe she was
And is
required
that
to.
well, not required to, but in determining whether or not the psychiatrist's conclusions were something on which it was reasonable to rely, isn't the commission entitled to say what kind of information did she base this on? She based it on, was this the third time she had met Ms. Kavaleski?
It was.
Yeah, and so wasn't coming at this without her own sort of filters already. The commission could look at, and could say, what else did she look at? Why can't the commission look at the basis on which this opinion was reached?
I think the commission can look at the
And
basis.
can say that here that wasn't enough. It wasn't enough for her to just look at the testing and her own third interview with the same person, which she had basically failed twice before, something more might have been necessary.
Again, that's something within the purview of the department to determine what is necessary. And in this case, Dr. Reed followed the approved plan. There was phase 1 of the testing, phase 2 of the first level screen, phase 3 of the evaluation with Dr. Reed. And Dr. Reed reviewed the wealth of information that was before her, and I would submit it's no different than a non-psychological bypass case before the appeals court involving an appellant, David Suppo, where the court found you can rely on the incident report. The Boston Police Department has no obligation, nor is it required, to reach beyond the facts in the incident report to determine whether or not that's a reliable set of information.
But isn't it, I mean, the difference is, those are facts, or anyway, it's objective, did these things happen or not. Here we've got the same person 3 times performing what is purporting to be a neutral second opinion. I mean, it just from the starting gate, it seems to me to be problematic.
In response, Your Honor, I would note that, yes, it is the 3rd evaluation, but there was nothing in the record to indicate any bias or that was being applied against Ms. Kavaleski. And I would note that Dr. Reed actually acknowledged an improvement. She said, Ms. Kavaleski does seem to be more spontaneous in this interview.
Damning with faint praise. I mean, it's most of the report of 3 pages is about what happened in interviews 1 and 2.
Because those were considered. I think that Dr. Reed had an obligation to consider those, but Dr. Reed was also very clear in identifying the continued pattern of behavior regarding Ms. Kavaleski that were of concern to her. Psychologically inflexible, an interpersonally stiff woman, and all of that would impact her ability to reflect on decision-making, her actions, and her impact on others, all of which would prevent her from performing the essential functions of a Boston police officer. And in this record, there was nothing before the commission to contradict those findings. It was very reasonable for the department to rely on those findings, which involved the approved psychological screening plan process, reliance on not just the interviews, but Dr. Reed's review of Ms. Kavaleski's background, as well as her test results.
You say there was nothing to counter that? What about these fairly remarkable and detailed evaluations from people with whom she's worked?
Those are not psychological assessments. Dr. Reed looks at it in a very
But there's no
specific
behaviors
focus.
reflected in those relationships that would be consistent with this psychological assessment, right?
There's also nothing to indicate that those particular supervisors were looking for these behaviors and addressing them in relation to an application for police officer.
You agree that, or maybe I'm wrong, it is the police department's burden to justify before the commission, correct?
Yes, the reasonable justification, yes.
So are you suggesting that the commission has to accept the justification unless, in this kind of case, Ms. Kavaleski comes with an expert to say, no, she's psychologically okay?
It is an expert evaluation, so yes, I do believe in.
What if the commission just doesn't believe your expert?
Well, I guess that's up to them, but on what basis?
It's your burden.
But on what basis is the commission not believing the expert? There has to be some foundation for that. It can't simply be the conclusory statement that we don't buy the science, therefore we're disregarding your expert and giving this appellant another opportunity, which I do.
But where is the science? I'm looking at this and I see that Dr. Reed disqualified her, describing her as a psychologically inflexible, interpersonally stiff woman whose extreme defensiveness limits her capacity to reflect on her own decision-making responses. Is that something? Isn't that common parlance? Isn't that what we all as human beings say when we give our assessments of people's personalities? Do you need a psychologist to say that?
I think in this case you do, because you need an expert to look at the test results, look for corroborating evidence in the interview. I'm not going to pretend to know how to meet with somebody and then identify concerning behaviors or traits that are going to limit their abilities to be a police officer. That's why we employ these experts to make those assessments as the only individuals, and in this case, the only testimony in the record from somebody qualified to make those judgments.
Do you agree with the blue brief that, I think I got this from the blue brief, there was some suggestion that Dr. Reed herself wasn't saying that she had the necessary expertise to assess what the meaning of the MMPI results were?
I'm sorry, Your Honor, did you say that she did or did not?
Did not.
No, I believe her testimony was that she does have the requisite knowledge, and on occasion, if
Well,
there's
it
a
actually
question.
requires training, not just some familiarity with.
And she does have the training, and in this case, I believe her testimony was there was no need to consult with anybody with regards to the test results portrayed through Ms. Kavaleski's answers.
I don't know, what did that mean?
That Dr. Reed felt that she had the requisite training and knowledge to take those results and use the traits and look for those as a jumping off point in the interview.
Ordinarily, isn't it the case that in order to evaluate what the meaning of the results is, I mean, you don't just look at numbers and you say, this, tote them up and say, oh, here's a problem. You need someone with expertise. Doesn't necessarily have to be a psychologist, can be a psychiatrist, but training and expertise in the particular category of these tests, how you assess them, what the outcomes mean. So isn't she suggesting that she didn't feel the need to look to someone with that expertise, suggesting she doesn't actually have the training and expertise?
No, I respectfully disagree. And with regards to the testing, you don't just get the numbers. In this particular case, for example, the MMPI computer-generated score indicated that Ms. Kavaleski's answers indicated she was trying to make a good impression on others, attempted to minimize problems and deny faults, that she has little psychological insight and is reluctant to engage in self-evaluation, and had she responded more openly, the results would likely have endorsed more symptoms, generated by the test, arguably speaking for itself. I see that I'm nearing the end of my time. I do want to address the...
No, you've...
Oh, I'm over. Oh.
Yes, ma'am.
Then at that, I will rest on the brief. Thank you, Your Honors, for your time.
All right. Thank you very much.